CD. And so after reviewing those cases, again, the standard is, after viewing the evidence in light most favorable to the prosecution, any rational trier of fact could find beyond a reasonable doubt that the defendant is guilty of the offense. And Millen versus State laid out what the standard is. In short, if evidence demonstrates that the defendant intended to cause or result the death of a person, that he did so with premeditation and deliberation, then the killing of another, even if not the intended victim, intended result is first-degree murder. So, also, State v. Claxton sets forward things that can be considered for premeditation: the use of a deadly weapon upon an unarmed victim, the particular cruelty of the killing, declarations by the defendant of the intent to kill, evidence of procurement of a weapon, preparation before the killing for concealment of the crime, and calmness immediately after the killing. And so, in considering those things, the court finds that there is sufficient evidence for this matter to go forward with the jury, because although the defendant may not have intended to kill Miss Perry, the law says that all that's required is that she had the intent to kill a person, and that person would have been Brodes Perry, who was shot multiple times. So, in considering all those things, the court finds that there is sufficient evidence for this matter to proceed to the jury. I know there was some indication about felony murder, but that case also, it said something about criminal attempt murder. Whenever it's not the intended victim, should be felony murder, but that case also says that it can be criminal attempt premeditated murder as well, just not felony murder, just when it's not the intended victim. So the court finds that there's sufficient evidence, and because the court finds that there's sufficient evidence on criminal attempt murder 1 and count 2, the court also finds that there is sufficient evidence for the case to go forward to the jury on employment of a firearm. As indicated in my previous ruling, the defendant used the allegation that she used the firearm in commission of the criminal attempt murder, which the court finds that there is sufficient evidence for that to go forward to the jury that she did so intentionally. So the court's going to deny the motion for judgment of acquittal at this time.
Thank you, Your Honor.
And then there was a second issue, and I guess we can approach it at that. And I made one more correction on the criminal attempt first-degree murder. And I think she sent that out to you. Were there any corrections or anything from what the parties saw?
I did, Your Honor. I don't know if the state wants to go first.
I just have one issue that and it's always been something I haven't understood. So when the definitions of intentionally and transferred intent is in second-degree murder, but not in first-degree murder, and I don't understand why that is.
You said second.
Right, and so my position is that that language should be in the charge for murder one, because it is a criminal attempt murder one. It doesn't
Criminal
affect,
attempt, second degree murder, or just second degree?
well, so, yeah, so the transfer of intent element is, so the criminal intent, by the time you get there, the court is saying, I've already defined.
I changed that.
Oh, did you?
I did.
Okay.
Because the criminal attempt, for serious bodily injury, I included, hold on one minute, make sure she said she was correct.
And she may have. I
We
just-
got a corrected one last night,
Okay, it's another.
or this
one.
morning, actually.
Now, let me make sure.
There you go.
That fixes my issue.
Okay. Did you have anything else?
No, ma'am. That's all.
Okay, all right,
I just note my objection to the change.
okay. All right. Did you have any other changes, Ms. Fuchs?
Yes, Your Honor.
Okay.
On page 2, this is a unique situation in that at the last paragraph, or the last sentence of the paragraphs regarding first degree and criminal intent first degree, it says that Latoshia Daniels pleads not guilty to every count as encompassed, to every charge as encompassed. And we are not saying that she is not guilty of all of those offenses. We are saying that she is not guilty of first degree murder, she is not guilty of second degree murder, that this is at best a voluntary manslaughter. So I would like to take that language out, or at least change it to has pled guilty to the originally charged offense, or something along those lines.
Which part are you talking?
It's page 2, it's the last sentence.
Oh. The defendant pleads not guilty to each and every offense and breaks and not, you just want me to take that out completely on each one of them?
Yes.
Okay, that's fine, I can do that. Any objection from the state?
No, ma'am.
Okay, you have to take that out. No problem. Anything else?
Yes, Your Honor. Regarding the section on defendant testifying,
Let's see.
it's on,
I know they're not numbers. Let's see.
It's after direct and circumstantial evidence.
Okay, defendant testifying, yes.
Your Honor, I would just ask, it does say like subject to all of the rules that apply to judging the credibility of other witnesses. I would just ask that it be made clear that just like with other witnesses, the law presumes that a testifying witness is telling the truth and to be given a full and fair consideration. I mean, really that first paragraph of credibility of the witness, minus all of the factors that they need to look at, I would suggest adding into that defendant testifying so that it's clear that the same rules apply for Ms. Daniels as applied to all of the other witnesses.
So what are you suggesting to add? What language are you suggesting?
The, if you go to, so it's kind of cross-referencing, if you go to the credibility of the witness,
Okay, I'm
that's
there.
25 pages in, that
Yes.
first paragraph that says, if there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can.
Mhm.
For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important their testimony was. You do not have to accept that basically that whole first paragraph for the credibility of the witnesses. But particularly the fact that the law presumes that witnesses are testifying truthfully if the jury can find them. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. Just because it's one says witnesses and one says defendants, so I want to make clear that the defendant is a witness that also has the presumption that they are telling the truth.
Okay, so the language specifically that you want to add is, I want to make sure I have that clear.
If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth.
And then keep her credibility is determined by the same rules of credibility of other witnesses determined. So you just want to add that one sentence.
Yes.
All right, what's the state's position on that?
It's the pattern instruction. It's clear to me. I don't see a reason to change with the instructions from the AOCR on that.
Well, it's kind of duplicitous because I'm telling them that she's determined by the same rule of credibility of other witnesses, and then this is a section on credibility of witnesses, and those
Well,
are the
then,
rules.
what we could do in the alternative would be in the credibility of a witness section, include a phrase that, you know, the credibility of the witnesses, the law presumes that every witness, including the defendant in this case, that would achieve the same goal. I just want to make clear that the law also presumes that Ms. Daniels is telling the truth, just as it does with all of the other witnesses.
What's the state's position on that?
Again, I don't know how that's not clear. She's a witness, and it specifically just tells the jury that they're to judge her by the same credibility as every other witness. Adding anything just like almost emphasizes to the jury that you should believe the defendant more than any other witness in the state's mind. That's not appropriate. So the charge is clear, and it's the pattern charge, and I'm opposed to any change in that.
Your Honor, I disagree. I think that when we have referred to witnesses throughout this entire trial, and we have referred to the defendant throughout the entire trial, those sound like two separate parties. And so if the jury's not clear that even though she is the defendant, she also, under the law and under the instructions, is a witness that should be treated the same way as the other witnesses, then that's impairing her right to have a fair consideration by the jury.
Or can we just say that the defendant is a witness and without all this?
I mean, I think if adding
Defendant
that,
having testified, defendant as a witness, having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you would have to give the defendant's testimony, in this case, such weight as you may think it is entitled.
that's, Your Honor, I guess my issue with that is that the language in those two sections are very different. The language between the general credibility of a witness and the assessing the defendant testimony is very different language. Give it whatever weight you think it deserves is very different than the law presumes that these people are telling the truth.
I'll come back to that one.
Your Honor, there also, we had talked a little bit a couple months ago about the Supreme Court denial of certiorari from Sotomayor regarding Tennessee's instructions on second-degree murder and voluntary manslaughter. Justice Sotomayor took the position that Tennessee's instructions for sequential considerations in regards to second-degree murder and voluntary manslaughter are unconstitutional. And that is because voluntary manslaughter actually has an extra element that is not in second-degree murder. And we should be moving down and reducing elements rather than adding them. As far as the order of consideration being sequential, I would ask that the court instruct the jury to consider second-degree murder and voluntary manslaughter together rather than sequentially, because voluntary manslaughter has that separate element that makes it different than second-degree murder, but it's an additional element, an additional finding that the jury would not be able to get to if they did not move past second degree. So I would just ask on the sequential consideration to consider those two together.
What's the state's position?
I don't, that opinion did not change the law in Tennessee. It was one justice's opinion who was in the minority. Until the law changes, I think it's clear that the way we charge this in Tennessee is first degree, second degree, and then voluntary manslaughter.
I mean, I get your point. I mean, it makes sense, but, you know, at this time, the law is what the law is. But I definitely get it. You know, it's an additional element, but the law, at this point, I have to follow what the law is currently. And so I note your objection because I get it's an additional element. And usually when it's a lesser included, it's one that goes, you know, it's a less element, but in this case, there is an additional element. And so it makes sense to me, but, you know, I have to follow what the law is currently, which they go in that order. So I'm gonna have to overrule that objection at this time.
Thank you, Your Honor. And then I would just note on page 39, there was a somewhat duplicative,
Which one?
it was no outside communications, but on page 2, there's no independent research or discussions. So I just wanted to note the duplication.
Okay.
And it's not an exact duplication, but it's very, very similar.
Okay. You have any objection to that being removed?
No, ma'am.
All right. All right, give me a second on that other one. I have to step off and do a little research.
Thank you, Your Honor.
All right. On the defendant testifying, I'm gonna leave the instruction the same, because I don't wanna, I mean, the language, I feel like it's duplicitous to put that in there twice, because the defendant testified she's treated as a witness, and the instructions say her credibility is determined by the same rules that the credibility of other witnesses is determined. And so the credibility of witnesses, there's a section titled that with everything that she's supposed to be given the same weight as everyone else. So I'm gonna deny that request at this time.
And Your Honor will not consider even adding the language that you had suggested about saying when she testifies, she's considered a witness.
I'm gonna leave it the same. All right, were there any other corrections? I gave you each a copy. Y'all gonna take a moment to look at it to make sure there's not anything else before we print them off.
If we could have a minute, please.
Okay, sure.
On intentionality, the pattern instruction,
Which one?
um,
Which section?
what was added to the criminal attempt?
That's a pattern instruction for criminal attempt. First degree murder with serious bodily injury. That's the pattern instruction.
Is it the pattern instruction for regular first degree?
There is two separate instructions. It's one for first degree murder, and then there's a separate instruction for criminal attempt, first degree murder with serious bodily injury.
Yes.
There's a separate
So,
instruction.
I guess my issue is that by we're adding language to the criminal attempt first degree murder that's not in the pattern instruction. This says the essential elements necessary to constitute first degree murder are. And then it goes into that paragraph that is not part of the pattern instruction.
I think that's what's, hold on. 401A.
That's telling the jury this is first degree murder, but it's different than the pattern given for first degree murder.
It's an attempt, so it said the defendant unlawfully killed the alleged victim, that the defendant acted intentionally. Oh, we forgot, and the killing was premeditated. One, I'm gonna make sure she had that. That's the instruction. That the essential elements necessary to constitute first-degree murder are the defendant unlawfully kills the alleged victim. That's under the first-degree murder. In count one, the defendant acted intentionally. That's there, and that the killing was premeditated.
Yes. But what I'm looking at on the instructions that you're giving for first-degree murder says that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim.
Right. And so, what's the
So-
additional language is not there?
It just is, I think it will be confusing to have two different definitions of first-degree murder in the same.
The difference is that because it's criminal attempt first-degree murder, there's a reference to Millen, State v. Millen, and the fact that you can have the intent to
Kill another person.
kill another person. And so I think that's why the additional language is there in criminal attempt first-degree murder versus first-degree murder. Because of the fact that you can get criminal attempt murder by just having the intent to kill someone, not necessarily the person who is alleged in the indictment. So I think that's what the distinction is.
Okay. I just was concerned by the fact that we have two different definitions of first-degree
Yeah,
murder.
I think it's just different because of that. In the pattern instructions, that language is there, and I think it's because of their law, and that's bracketed language. What I included, so it's not always included, but I included that because there's an issue about intent. You know, whether she had the intent to kill Miss Perry. So it's bracketed language. It's not necessarily required to be included in there, but I included in there because of the proof that came out.
Thank you, Erin.
All right, you're welcome.
Would Your Honor consider, given the issues about the voluntary manslaughter and second-degree murder, would you consider a sentence at the end of the first paragraph under second degree indicating with second degree, the jury should take it, or should consider whether a heat of passion was present at the time of the alleged killing? Putting that they should be considering that at that point in time as a way to address that issue?
This is a pattern instruction. So do you have any case law to say that I can't do that?
Your Honor you are allowed to change instructions. We're allowed to draft instructions and put them forward for the court's approval. They just have to comport with the law. And as long as they comport with the law, the court is allowed discretion within the jury instructions.
Okay, what is it you're asking for again?
So because of this issue, that is a very new issue brought up by that denial of writ with Sotomayor basically telling Tennessee Supreme Court, you need to fix this. It is currently unconstitutional. We have been told by the United States Supreme Court that our jury instruction framework is unconstitutional. This is a way to address that so that Ms. Daniels gets a fair consideration by this court when they're comparing second-degree murder and voluntary manslaughter. And especially in this kind of case when we're saying this is a voluntary manslaughter, that for them to not be allowed to move to that section because of the way that our jury instructions are ordered completely denies her right to a fair trial. So if we just added a sentence to say, you know, this is the distinction between voluntary manslaughter and second-degree murder, is that voluntary manslaughter requires the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Even if you just said, you know, like the jury should consider whether a heat of passion was present during this alleged shooting. Here.
I think it's already saying that though, because, I mean, it's showing you distinction between both, and so.
Yes, but it's not telling them to consider voluntary manslaughter yet.
What's the state's position?
The law in Tennessee is that you charge first-degree murder, second-degree murder, and voluntary manslaughter. So that changes. I think that's what the court should do.
And I get your point, Ms. Speaks. I do, I understand what you're saying. It's just, this is the law, and I have to follow what the law is. But I get your point.
And I'm not asking you to change the law. I'm asking you to provide some clarification to the jurors regarding that. And that's what these instructions are supposed to do. They're supposed to help guide them through this process. And when we have a situation to where second-degree murder and voluntary manslaughter are sequential, they don't move to that heat of passion according to the jury instructions. They don't move to that heat of passion until they completely acquit of second-degree murder. Then if you don't tell them, you need to take this into consideration here before you, I mean, like if in the decision on whether or not to acquit on second degree and move down to voluntary manslaughter, then they don't get to the point that they are able to consider that as an element. That's asking them to do the cafeteria style that we're not allowed to do.
I mean, these are the pattern instructions adopted by Supreme Court, and at this point, I'm gonna deny the request. I get it, but I'm gonna deny the request because that, I mean, these are what they have set out, you know, what we're to use. So at this point, I'm gonna deny the request.
Given the fact that the jury instruction requests specifically are supposed to be in writing, would the court give me a moment just to draft a pleading so that I can file it, to have it in writing to make the record?
Yes.
Thank you. No, Your Honor, I will include in that written request my additional request for the language regarding the defendant and witness credibility.
Okay. But other than that, there's no, those objections, was there anything else?
Oh, the issue, did you take out the language of the not pleading not guilty?
Yes, I took that out. Did the state have any corrections?
No, ma'am.
Before the section on defendant testifying?
What's the state's position?
I thought that's generally given when the defendant doesn't testify. So I'm not sure what the purpose of it is if the defendant testifies.
What's the point?
Your Honor, it's to clarify the burden of proof. It is to make clear, and I'm checking the burden of proof section now. But being clear that that does not place a burden of proof on the defendant.
Let's see this. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts or remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. So I think that's good. She doesn't have to prove anything.
Crime charged and plea?
Oh, okay. Let's change the crime charge.
Yes.
Correct.
Or if we wanted to leave the and plea, we could add a second, like a final sentence that says the defendant pleads not guilty to the offenses as charged.
What's the state's position on
Either one of those is.
I'd prefer the second.
it? The defendant,
Pleads not guilty to the offenses as charged in the indictment.
defendant pleads not guilty to the as charged, is what it is charged in
To the
indictment?
offenses as charged in the indictment.
Okay.
And just semantically, I'd probably rather offenses charged rather than crime charged.
What do you mean on the heading, offenses charged?
Yes.
What's the state's position?
Yeah, I can give it an answer. I mean, it's a crime. It's charged as a crime, and that's what this charge says. So I don't know why we would change that.
Offenses charged, crime, same thing. Offenses charged. So do you want to keep the language about the plea?
If we could just add that final sentence, the defendant pleads not guilty to the offenses as charged in the indictment.
Okay, but the heading, you want.
Yes, then we can
offenses
leave
charged.
it offenses charged and plea. And then it outlines the offenses and then gives the plea.
Okay. All right, so were there any other changes besides that? Before we make the copies? I note your objection.
Thank you, Your Honor. I do have that written request on the way.
Okay.
thought of when you walked out was adding page numbers.
Okay. Page. What's your position, Mr. Lincoln?
I don't have a position on page numbers.
Okay.
We don't, if you've already started printing.
We haven't printed it yet. Okay.
Just kind of as a logistics matter, are we planning to charge lunch close? It's 11:15 now.
I know, and it's looking like it's gonna be that way, but I was hoping that we could get it done before lunch, but it's probably not going to happen, but I was hoping.
The court could limit the time for court.
To do that. But, okay. All right.
before the juror comes in?
Not from the state, no.
Okay, all right, we can get the juror in.
Jurors are in the courtroom, Your Honor.
You may be seated.
Good morning.
Good morning. While we're ready to get back to work, it's now time for me to instruct you on the law. If you could pass them a copy of the instructions. Do we have a copy? State of Tennessee versus Latoshia Daniels, indictment number 2501253. Members of the jury, the evidence in this case has been completed and the arguments are soon to follow. Now it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. Offenses, charge, and plea. The defendant, Latoshia Daniels, is charged in count 1 of the indictment with the crime of murder first degree. The offense necessarily includes the lesser offenses of murder second degree, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant, Latoshia Daniels, is charged in count 2 of the indictment with the crime of criminal attempt murder first degree. The offense necessarily includes the lesser offenses of criminal attempt murder second degree, criminal attempt voluntary manslaughter, and reckless endangerment. The defendant, Latoshia Daniels, is charged in count 3 of the indictment with the crime of employing a firearm during a felony. The offense necessarily includes the lesser offense of possessing a firearm during a felony. The defendant pleads not guilty to the offenses as charged in the indictment. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them on the trial and under the law given them by the court, render their verdict with absolute impartiality. No independent research or discussion. You as jurors must decide this case based solely on the evidence presented here within the 4 walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you this case is interesting and noteworthy. I know that many of you use cell phones, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. Notes. Members of the jury, you have been allowed to take notes in this case. The court charges you that these notes are for your individual use only, and you should not use said notes directly or indirectly to persuade other jurors as to the accuracy of said notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by the maker of said notes as an aid to his or her individual memory. Indictment. The indictment in this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements and arguments of counsel. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The court will now explain to you the law applicable to count 1 of this indictment, murder first degree premeditated killing. Any person who commits the offense of first degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the crime after the passion has subsided. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intends to cause result the death of a person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Intentionally and knowingly have previously been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, Brodes Perry, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and a degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined in these instructions. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant's conduct resulted in the death of the alleged victim, Brodes Perry, and 2. That the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2, criminal attempt first-degree murder charged in this indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder where the victim suffers serious bodily injury is guilty of a crime. For you to find a person guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant intended to commit the offense of first-degree murder against alleged victim Tabatha Perry, and 2B. That the defendant did some act intended to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. And 3. That the alleged victim, Tabatha Perry, suffered serious bodily injury. New and known means that a person acts knowingly with respect to the conduct or to circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute first-degree murder are 1. That the defendant unlawfully killed the alleged victim, and 2. That the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that she did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a bodily function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Criminal attempt, second-degree murder. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2B, that the defendant did some act intended to cause an essential element of second-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended, intending, intent has previously been defined in these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute second-degree murder have previously been defined in these instructions. Criminal attempt, voluntary manslaughter. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of voluntary manslaughter, and 2B, that the defendant did some act intended to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intended, intending, intent have previously been defined in these instructions. The essential elements necessary to constitute voluntary manslaughter have previously been defined in these instructions. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in a zone of danger. The zone of danger is that area in which reasonable probability exists that the defendant's conduct will place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Recklessly, intentionally, and knowingly have previously been defined in these instructions. The court will now explain to you the law applicable to count 3, employing a firearm during the felony charged in this indictment. Employing a firearm during the commission of a dangerous offense. Any person who employs a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm, and 2, that the employment was during the commission of or attempt to commit criminal attempt first-degree murder against alleged victim Tabatha Perry, and that the defendant acted intentionally, knowingly, or recklessly. Employ means make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily convertible to their use. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and justifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that a defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabatha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Unlawful possession of a firearm with intent to go armed during the commission of or attempt to commit a dangerous offense. Any person who possesses a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent to go armed during the commission of or attempt to commit criminal attempt first-degree murder, and 3, that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly, intent, and firearm have previously been defined in these instructions. Possession may be actual or constructive. A person who knowingly had direct physical control over an object at a given time is then in actual possession of it. A person who, although not in actual possession, knowingly had both the power and intention at any given time to exercise dominion and control over an object is then in constructive possession of it. Possession may also be sole or joint. If a person has actual or constructive possession of the thing, possession is sole. If 2 or more persons have actual or constructive possession of a thing, then possession is joint. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that the defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabatha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Presumption of innocence. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and that this presumption stands as a witness for her until it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict a defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and state of Tennessee before the finding of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof general. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. Burden of proof, elements and date of offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Impeachment of witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with the witness's evidence on the stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Excuse me. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it plainly appears that some witness has testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony about the facts and circumstances proved on the trial. Credibility of witnesses. You should consider all the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are, based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors. 1. How the witness looked, acted, and whether the witness appeared to be telling the truth when he or she testified. 2. Whether the witness was in a position to know about the manner to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard. 3. Whether the witness's statements were consistent and how believable the statements were. 4. Whether the witness had a motive to testify truthfully or to testify untruthfully. And 5. Any proof presented of the witness's reputation for telling the truth. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it plainly appears that the witness has willfully testified falsely. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or contradict him or her. Expert witness. During the trial, you heard the expert testimony of Erica Curry, a forensic pathologist. Dr. Amanda R. Bidding, during the trial, you heard the expert testimony of Erica Curry, in forensic pathology, Dr. Amanda R. Bidding, PhD, in forensic and clinical psychology, and Special Agent Brock Sane in firearms identification, all were who would describe to us as experts in their fields. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background and training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Identification. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which she is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Latoshia Daniels, committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether she has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence, direct and circumstantial. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever way you believe it deserves. Defendant testifying. The defendant having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will give to the defendant's testimony in this case such weight as you may think it is entitled. Unanimous verdict. The verdict must present the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliver with a view to reaching an agreement if you can do so without violence to an individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Unanimous means agreeing in opinion, being in complete accord, agreement of all jurors in holding one and the same opinion. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You should not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that account, you should return a verdict of not guilty and proceed to the next count. The charged offense in count 1 of this indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of first-degree murder as charged in count 1 in indictment 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of lesser included offense in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of lesser included offense beyond a reasonable doubt, if you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 1 in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 1 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 2 of this indictment is criminal attempt first-degree murder. The lesser included offenses in order of consideration from greatest to least are criminal attempt second-degree murder, criminal attempt voluntary manslaughter, reckless endangerment. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count 2 in indictment number 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt to this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 2 in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 3 of this indictment is employing a firearm during a felony. The lesser included offense is possession of a firearm during a felony. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of employment of a firearm during a felony as charged in count 3 in indictment number 2501253. If you find the defendant guilty of this charge, you must identify the felony, either criminal attempt first-degree murder checkbox, criminal attempt second-degree murder, criminal attempt voluntary manslaughter checkbox. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of the lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 indictment number 2501253, insert in said blank the lesser included offense. If you find the defendant guilty of the lesser included offense, you must identify the felony, either criminal attempt first degree murder, criminal attempt second degree murder, or criminal attempt voluntary manslaughter. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 3, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. Selecting foreperson. When you retire to the jury room, you will first select one of your members as foreperson, who will preside over your deliberations. When you have reached a verdict, you return with it to this courtroom, and your foreperson will announce the appropriate verdict form to the court. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. Signed, Judge Jennifer Fitzgerald, Criminal Court, Division 2. All right, so I have given you the law in this case. We're going to recess for lunch, and when we come back, you'll hear the attorney's closing arguments. And I have to remind you again, we're still not ready to discuss the case, okay? So I'm gonna excuse you for lunch. We'll come back, I guess at 1:45. I'm not sure if lunch too yet. We'll come back at 1:45. But I'm gonna excuse you for lunch, and we're still not ready to discuss the case.
Let's leave your paperwork in your chairs, please.
Do you want me to have yours copy stamped or do you?
All right, we can come back at 1:45. may be seated.
Welcome back. Hope you enjoyed lunch.
We're ready to go forward with the closing arguments. State.
You broke my heart. I felt used. He broke up with me in a disappearing text message. Who does that to someone that they love? I wanted him to feel the pain that I felt. These are the words of the defendant, Latoshia Daniels. And earlier this week, we told you that you would hear a lot of testimony. You would see some pictures, you would see some videos, but most importantly, we wanted you to pay attention. And a key part of paying attention is not getting distracted, not getting confused as to who the victim is. The victims in this case are Mr. and Mrs. Perry, not the defendant. The decisions that she made caused them to be victims. And once we're finished here today, you'll see that this case really isn't that complicated. It's kind of easy. She's charged with 3 counts: first-degree murder, criminal attempt first-degree murder, and employing a firearm during the commission of a dangerous felony. First-degree murder, and you'll see this in your jury instructions, is defined as a premeditated killing of another. 1, the state has to prove that the defendant unlawfully killed a victim. 2, the defendant must have acted intentionally. 3, the killing must be premeditated. So, what is considered unlawful? Well, what is considered a lawful killing? One example can be the defense of others or yourself. Intentional. What does it mean to be intentional? Does it seem like an accident? Does it seem like a mistake? Your jury instructions say that something is intentional if it's a person's conscious objective or desire to cause the death of another person. Number 3, premeditation. The killing has to be premeditated. And as we learned in voir dire, premeditation doesn't have to be a specific length of time. It could be 2 seconds, 2 days, 2 weeks, 2 months. There's no time frame. It just means that you had to think about your actions and you had time to reflect. That could be as simple as stepping out of your car, raising your arm, and the time it takes you to point the firearm at someone and shoot and kill them. Or in this case, it could be driving to the gun store, purchasing a gun, purchasing ammunition, leaving the gun store, driving 3 hours to Memphis to your married ex-boyfriend's house, and knocking on their door. So this week, we started off hearing from Tabatha Perry. She testified that her husband was an executive pastor in Little Rock, and later he moved to Memphis along with her for a new position at Mississippi Boulevard, a prominent church here in Memphis. She also testified that they knew the defendant. They knew her from Little Rock when he was previously working over there. And on April 4th, 2019, Mrs. Perry heard a knock at her door. When she went to her door, the defendant was standing there. Now, she thought it was odd that Ms. Daniels was standing there, but she didn't think too much of it because they had given their address out to several people at the church in Little Rock. After she let her in, Mrs. Perry and the defendant sat and talked about 20 minutes until Brodes Perry showed up. When Mr. Perry showed up, the defendant even told you that they sat and talked for a while. She even took a drink. And once she decided that it was time to go, Mrs. Perry and Mr. Perry led her out of their doorway And as Mrs. Perry was leading her out of the doorway, she turned back and she saw the defendant reach into her coat pocket, remove a gun, and shoot Mr. Perry in his own doorway. Once she did that, Mrs. Perry looked to her neighbors for help. She tried to get help, and then when she saw her husband lying on the ground, she went to go help him. She pleaded with the defendant, "Why are you doing this? Why is this happening? Please stop." Well, not only did the defendant not stop, she shot Mrs. Perry. And not only did she shoot Mrs. Perry, she reloaded her gun. After Mrs. Perry, we heard from Detective Roberts. He testified that the very weapon that was used to shoot Mr. and Mrs. Perry was purchased hours prior to this incident. He testified that the defendant purchased that firearm at a gun store at around 4:30 that same day in Sherman, Arkansas. Detective Roberts told us that he spoke to Ray Palladino, the general manager of that sporting goods store. From Mr. Palladino, he received the surveillance footage. And that surveillance footage showed the defendant coming in, purchasing a gun, purchasing ammunition, and leaving. Mr. Palladino also provided Detective Roberts with a receipt. That receipt had the defendant's first and last name on it. It had the serial number of the Ruger handgun that she purchased and the last 4 digits of her credit card. It's the same credit card that Detective Roberts discovered in the defendant's vehicle when he searched it. We also heard from Dr. Curry. Now, Dr. Curry testified that she performed Mr. Perry's autopsy. She testified that the cause of death was multiple gunshot wounds and the manner of death was homicide. She testified to recovering the bullets, placing them in an envelope, initialing and dating them, and leaving them to be picked up. But Dr. Curry isn't the only doctor we heard from. Defense put on Dr. Bidding. Dr. Bidding was hired by the defendant and her team. And you heard her, she testified that she has testified for more defendants than she has prosecution. And ladies and gentlemen, think carefully about what she told you. She told you that depression and someone being suicidal does not mean that they cannot form the intent to kill someone. She also told you that she didn't even offer an opinion as to the defendant's mental state at the time of the offense. So what do we need? We need an unlawful killing, intent, premeditation. Unlawful killing. Well, there was no self-defense claim, and the only other firearm found in the residence, found in the crime scene, was in a box under a nightstand in a completely separate room. Intent. I wanted him to feel the pain that I felt. He broke my heart. You heard that from the defendant herself. Premeditation. We'll take your pick. Whether it's the drive to the gun store, the time it took to purchase, choose a firearm and ammunition, the time it took to drive 3 hours to Memphis to her ex-boyfriend's house, or the 20-minute conversation she had when she finally went up to their apartment. Criminal attempt first-degree murder. So in your jury instructions, you'll see what's on the screen right here. And that's a lot of words. But the judge is giving you the law, and the best way that I can describe it is that the defendant must have an intent to commit first-degree murder. But they fell short for some reason. The act wasn't complete. And that's how you have criminal attempt first-degree murder. We heard from Tabatha Perry, and she testified that she was shot in the shoulder. After the incident, she was transported to the hospital, and the doctors left the bullet inside of her. It wasn't until later that she had to get it surgically removed. It was causing her extreme pain. And by the time that she got it removed, it was poking out of her back. And even today, 6 years later, she is still suffering from pain from that incident. Now let's talk about transfer of intent. You heard in your jury instructions that sometimes when you intend to kill one person and you don't kill that person but you kill another person, that is how the transfer intent happens. Tabatha Perry testified that when she spoke to the police, she told them that she didn't even believe that the defendant meant to hurt her. But that's okay, because you don't have to actually hit your intended target to be charged and convicted of criminal attempt first-degree murder. As long as you had the intent to kill one person, it doesn't matter that you accidentally shot or you actually shot someone else. Your intent is still there. The only thing that's different is the person that got hurt. Employing a firearm during a dangerous felony. So on the screen here, it says that any person who employs a firearm during the commission of a dangerous felony is guilty of a crime. The state has to prove that 1, that the defendant employed a firearm. 2, the employment was during the commission of or attempt to commit criminal attempt first-degree murder against the alleged victim, Tabatha Perry. And 3, that the defendant acted intentionally, knowing, or recklessly. In addition to Mrs. Perry's testimony, we heard from Captain Draper, Officer McLean, and Special Agent Broxane. Draper testified that he and McLean were a few of the officers that responded to the crime scene on the offense day. And when he got there, he witnessed the defendant holding a firearm. She refused to comply with orders. Captain Draper testified to the non-lethal force that was used to unarm her. Officer McLean testified to securing and clearing the weapon that the defendant had in her possession. He noticed that there was nothing in the chamber, but yet there was a magazine in the gun. Special Agent Sane testified to the ballistics. He examined the Ruger, the casings, and the bullets from the medical examiner. He determined that all the cartridge cases and the bullets had been fired from that same handgun that was recovered off of the defendant. And now we're back at the beginning. You broke my heart. So I'm going to purchase a firearm. You broke my heart. So I'm going to purchase ammunition. You broke my heart. So I'm going to take that gun and the ammunition and drive 3 hours away to your home. You broke my heart. So I'm going to knock on your door. You broke my heart. I'm going to sit there and talk with you and your wife for about 20 minutes. You broke my heart. So I decided to leave. You broke my heart. So I'm going to shoot you and kill you in your doorway, and along the way shoot your wife. But it's okay, because you broke my heart. Decision after decision after decision. Ladies and gentlemen, if a broken heart was an excuse or a defense to murder, I wouldn't have a job. The standard of proof in this case is beyond a reasonable doubt. Not 100% certainty, not beyond all doubt, not beyond a shadow of a doubt. What's required is certainty that lets you rest easy at night. And now it's your turn. After you consider all of the evidence and apply the law that the judge has given you and use your common sense, the state is confident that your verdict will be guilty as charged. Don't let a broken heart distract you from the human life that was lost. Thank you.
Mayor, may we approach?
Yes. All right, jurors, I want to remind you that the lawyer's statements are not evidence. And you can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. So we're going to take a short recess and then we'll be back for the next closing argument. So, and we're still not ready to discuss the case. Okay, so I'm going to show you excuse for about 5 minutes and we'll come right back. Take a 5-minute recess.
Thank you. I'm going to step down to the restroom real quick before.
may proceed. Does the defense wish to make a closing statement?
Yes, Your Honor.
You may proceed.
Thank you. Good afternoon.
Good afternoon.
We have told you from the very beginning that Ms. Daniels is not denying what happened. She is not saying, I have no responsibility. I have no accountability. That is not our position, and it has not been our position from the first time that we talked in Wood Island. We told you she is guilty of something, but she is not guilty of first-degree murder and criminal attempt first-degree murder and employing a firearm during a felony. That is not what these facts illustrate, unless you're looking at them from far, far away and ignoring all of the details and all of the intent. When I was in high school, one of the formative trips that I took, my mom and I went to Barcelona, and we went to the Museum of Salvador Dali. This man had the most amazing brain. He could paint pictures that from far away looked like one thing, and then when you got close up on them, looked like something completely different. And I will never, ever forget standing in the top balcony of that museum, looking across the way and seeing this. And there's a little plaque that tells you, squint your eyes and look at it. What do you see? I saw Abraham Lincoln. I absolutely saw Abraham Lincoln. And then, when you walk back around, they tell you how to get up there. This is that painting close up. It's something completely different. Not only a different picture, but an entirely different emotional response. You would never think that that was the Abraham Lincoln that you had just seen. But that can be the difference between looking at something from far, far away and ignoring the details versus seeing the intricacies of what it is actually made of. I want to talk to you first about Brodes Perry. We've heard a lot about him this week. He was a pastor at St. Mark Baptist Church in Little Rock. He was the leader of the life groups there. He was married to Tabatha Perry. This is what people standing far away saw. But when you got much more close, when you got to know Brodes Perry the way Latoshia knew Brodes Perry, you started to see a different side. And sometimes even then, you miss it. He was a manipulative person. I know that he is not here anymore, and that is a tragedy. But that doesn't change the fact that during his time on earth, he manipulated the women in his life. He was controlling. And he wanted this lifestyle of ethical non-monogamy. Regarding the ethical non-monogamy, that was, when I talk about the manipulation of women in his life, that was a big source of it. He manipulated Tabatha into thinking, oh, well, this is just something that I thought about. It's okay that you don't want to do it. He manipulated Chriselle and Danielle, who he had the Marco Polo group with, in that he made this whole fiction where his wife was completely on board with this, and he was living this open, honest, and transparent lifestyle where he was ethically engaging in non-monogamy. As a pastor of the church looking for a group of people who would sanction his behavior, he found these women, educated women, and lied to them about this. He manipulated Latoshia in so many ways. But regarding the ethical non-monogamy, his position was, my wife says it's okay, so my girlfriend should not be saying no. Even to Latoshia, he lied about Tabatha being opposed to this lifestyle. When Latoshia got involved, she thought Tabatha was on board with this ethical non-monogamy. And she was not. We heard from Brodes Perry
And
manipulating these women.
Those aren't an issue at home, but I get it, but it ain't an issue. I have been though, so if we talking, let's switch subject and get a little more serious. You know, for me, our agreements have been simple, right? No exes, nobody from Jacksonville, Florida, which is home for us, and nobody in the city that you live in, that currently live in, which means nobody in Memphis. That was the case, of course, in Little Rock, outside of Girlfriend, because Girlfriend is in Little Rock. The way that kind of happened is, short version, when she decided to open up the marriage and allow me to be on the good side of her. Girlfriend is a therapist, right? And she didn't go to her for therapy, but she asked her some questions. And based on this therapy session she had with this other lady. And she was asking her some questions after she had just said, bro, is this what I'm gonna let you do? Blah, blah, blah. You know, it is what it is. Go from there. She asked her some questions. And so she was like, I just got a couple questions for you. And, you know, they would go play tennis together. She was one of my life group leaders. And so we had rapport. We had rapport. And she asked a question and it was like, yeah, blase, I'm thinking about this. And what do you think about this? Or what do you think X, Y, and Z could potentially become from? And I'm sorry, I'm looking to see who was in the cigar lounge because this is not what I really frequent that often. So I'm kind of careful about who potentially is in here because I don't want to pass on past. You know, I really want to go in and go chill in the back, but I'm not a member. But yeah, I'm trying to debate on what's going in there now. But anyway, so the next thing that she shared with her was, you know my husband like you, right? Well, he thinks you're attractive. And she was like, what? He's like, yeah, I know what he likes, and he thinks you're attractive. Not that he's been rude or anything like that. We've had conversations. Well, you know, we did, because one time we was sitting around having a watch. And she asked me, I was like, well, you gotta get her. I ain't gonna get her, I'm coming across with this creepy guy, right? We're trying to spice things up. In that regard, even though that was even somewhat limited with the idea of somebody watching it, that's neither here nor there. But when the question came up, it was her, right there. The shit she asked, well, who would you want? And that was the first thing in my stage. She's like, I know you like her. How could I know what? So anyway, so she said, like you know, blah, blah, blah. And she said, well, if you were interested, just, I'm not saying that you are, but I'm also saying I've given him this X, Y, and Z, and he may come your way. And she did. But she's like, okay, cool. So we had a conversation. And after that, that's when the whole nobody in the city thing came up. It was more like, I'll give you a pass with her because I essentially gave you the alley. But nobody. So I'm trying to figure this. So fast forward, that's a whole lot of shit, right? Trying to get the way. So I've been thinking about, the past couple weeks in terms of expanding, my ethical non-monogamy, and just kind of, so my wife, her and I, we were chatting over there. I was like, well, baby, I got a couple questions. I'm just curious, She knows about the, everything like that. So I was like, when do you want to know? When do you want to know that there's someone who has my interest or someone who I would like to pursue? Do you want to know the moment that I feel like it's more than just banter? Do you want to know at the moment that I would like to begin to banter? Do you want to know once I feel like it might be a thing beyond banter? Or what? Because this is kind of new for us, right? Because, girlfriend, Tasha, that's easy. That's been 2 years. That's been it for the most part. Outside of me going, that's out for my birthday. But it's kind of been easy in that regard. So we're trying to figure out what does that look like. So I'm just kind of really thinking through where I am with that, right? Where I, in terms of those. So there's a lot of newness. I kind of say that just to say that there's still. Just to say that there's still a lot of newness even in this ethical non-monogamy that I'm wrestling with. And it's fun, right? It's fun, it's interesting, it's causing us to communicate and chat and really talk again about different things that we've kind of, in a real sense, have been settled to some degree. But realizing that in this ethical non-monogamy, we got to keep things in pencil and not pen. Some things are in pencil, pen, right? There's some hard news, but gotta be inflexible in terms of what that looks like. So that's why I know you're talking about being sprung and giddy and all that stuff. I think because those flutters or those emotions, right, or those initial thoughts are all kind of new and very much new because this person is brand new. Like, I don't know Cherie, right? I knew Tasha. That was different. There was some level of familiarity there. And that's typically how I've always engaged with it, right? With some level of familiarity. I cannot, whether being in the same class again in terms of college or something like that, I've never kind of quote unquote cold called anyone, if that makes sense. Because I'm not, I don't think I'm that guy. So, yeah. Thanks for coming to my TED Talk. I don't know if I'm gonna go in here, but now I'm thinking how far would we go downtown? Because I'm like, there's a lot of folk in there. I don't know if I trust who's in their room right now. Shit. Memphis need to do better with smoking houses, cigar houses. Now, I mean, I'm just, your opinion matters to me. Because we are in this relationship, but at the same time, like I said from the outset, I want to be respectful, but I also want to let you know that, your opinion matters. But at the same time, I don't want you to put me in a box, right? Because while we talked about it in theory, this is now the practice part. And with Tab being perfectly fine with the situation, because how I've handled and been honest and transparent and open with her with regard to this current relationship, me expanding it is not an issue for me. Basically, she told me, hey, we can talk about it when you think it's worth talking about. But the way that you handle this, I'm fine with, and I trust your judgment because you haven't given me a reason not to. It's only 2 hours away, but yes, we were in Little Rock, so we were literally that, because it was at that point, wife was like, yeah, nobody at home. Like, this is an exception because I kind of threw you that, but no, you ain't dealing with nobody at home. Like, that was Jacksonville, so our heart knows that no Jacksonville, which is hometown for us, no exes, and no place in your current city. Those are the hard no's, right? She got an exception because it was there that she realized, well, yeah, I don't think I want him to be dealing with all these people, all these women, and no doubt these women would be in the church because that's all we do is kind of hang around, or in the community or close enough. So it was kind of one of those things. But
Those are clips from approximately 13 videos where he talks and talks and talks, and none of it is true. None of it. You heard Tabatha sitting on the stand saying, my hard nose were all of those things and then some. My hard nose were him seeing anyone outside of our marriage. But that's not what he told Rochelle. That's not what he told Danielle. That's not what he told Latasha. He created this world of lies, this alternate reality in this chat room where he got everything that he wanted. He got validation. He got to have this lifestyle where he was cheating on multiple women, and it was okay. It was okay that he, as a pastor, do those things. That's what those women gave him. And for Latasha, she gave him whatever he wanted. And Tabatha was his wife. He took and took and took from these women. And the whole time, he was lying to all of them. I want to talk to you about Latoshia Daniels. From far away, Latasha appears to be a professional, educated, well-rounded woman. She's a licensed clinical social worker and went into a profession to help people. Church member, active in the church, a life group leader, selected among the thousands of people in church, and placed into a position of leadership by Brodes Perry. Did you notice in the one video he said, "What I typically do is engage with women from a position of familiarity." He knew how to attract the type of woman that he was looking for. And Latasha, when you got to know her and you got to see all of the details that make her up, she was exactly what he was looking for. She was so vulnerable because of the happiness being completely drained from her marriage, from the total lack of any emotional connection with her husband of 8 years. The traumatic history that she has had since a childhood, and always being told to keep a good face on. Her history of mental health, depression, suicidal ideations, suicidal attempts. Her dependency on other people. He knew that when he got his claws in her, she would do anything to keep him with her, including keeping his secrets. He also knew that Latasha would have to keep his secrets because she had just as much to lose as he did. He had to have someone who was in a good job, with a good appearance, because if they found out about this affair with the pastor, she would lose everything. All of her clients, the life that she had built up in the church, her family's opinion, all of it would be gone. And he reminded her of that. From far away, their relationship, it wasn't a fair. It was absolutely wrong. And it was neither of them took Tabatha's feelings into consideration. Neither of them. And they should have. Tabatha did not deserve that. But especially at the beginning, if you looked at that relationship more closely, there was a lot of love there. Latasha built her life around this man. He liked bourbon, so she started learning bourbon. He liked cigars, so she started learning about cigars. She got him into running with her. They joined a biking club together. All of these things that they built. And this woman who came into this relationship so starved for love and affection was receiving it, finally. And she never wanted that to stop. But when you looked at it more closely, you could also see Brodes behaving in a very controlling way, in a very manipulative way. And Latoshia was getting slung back and forth between these emotions of, oh, I love you. No, we're going to have some distance. This back and forth, pulling her heart in two pieces. And I will disagree with the state, because part of something that they have to prove beyond a reasonable doubt is intent. And one of the things that you have to look at is whether a heat of passion was present. And a broken heart definitely has to do with heat of passion. There is no emotion more powerful in this world than love. When she was with Brodes, Latoshia was required to follow certain rules. Rule number 1 that she learned on day 1. You download the Confide app, you use it the way I tell you to, and you only communicate with me in this manner unless I tell you different. Rule number 2, when Brodes took trips, Latoshia was expected to be there, and she had to pay her own way, whether she had the money to or not. Rule number 3, Latoshia was not to call anybody to come to them. Even in the case of a medical emergency, she was supposed to call Pastor Pointer. He knew about their relationship. He would get Brodes help, and nobody would have to find out about Latoshia. Rule number 4, Latoshia was not to approach him in public. He was only to approach her, because she didn't have a way of knowing if he was with someone for the church or with another pastor that may not know about their relationship. Very strict rules on what and when she could say to him. Rule number 5, when she was in a hotel room on one of their trips, she was to remain naked. Rule number 6, towards the end of their relationship, Brodes added that she should always respond to him with either yes, sir, or no, sir. And Latoshia followed all of those rules because she loved that man. And she loved the love that she felt like she was getting. And then things changed. On March the 15th, Brodes behaved in a very different way. He treated her like a piece of trash, like someone who was there for his use, not his love, not worthy of his affection. And something in Latoshia broke that day. And she decided that she was going to end her life. And yes, she did want him to feel that pain, because it was so much pain in her. And she came and never once threatened him. There was never a single allegation that she put him in any danger or threatened him or ever even pointed the gun at him. She actually gave the gun to him once he talked to her for about 2 hours. Brodes knew what to say to make Latoshia do what he wanted her to do. For good or for bad. And that day, he did get the gun from her, and he took the gun and kept it. She didn't see it after that day. Which brings us to April the 4th. Her gun, Brodes had put in a cigar locker in Little Rock. Latoshia did not have access to that. She opened did her normal good morning text to Brodes. And finally, when he responded, our time has come to an end. And then it disappeared. And in that moment of disappearing, 2 years of a life, of a relationship, of love, was gone. And Latoshia was still emotionally fragile from the traumatic experience on the 15th in March. Still suffering from those pains, but trying to work through it. And she decided that she was right the first time. She didn't need to be in this world. She couldn't be in this world. Not anymore. She had built her whole life around this man. And he broke up with her in a disappearing text. She apologized to her family and tried to make them understand that this is not something that she just thought about, that she's been struggling, and that the struggle was just too much. For this deeply religious woman to feel like God couldn't answer her prayers anymore because she was so deep down in this depression is just heart-wrenching. And that was at 3:14 p.m. on April the 4th. I'm having some technical difficulties. Okay. There we go. And so, after writing that suicide note, she did go to buy a gun. She didn't have one anymore, and she was going to kill herself. Yes, she planned to go buy a gun. That happened. She did not plan to go buy a gun to hurt anyone other than herself. She walked in, and you heard Mr. Palladino talk on the stand about the range of sizes and weights and prices. If you recall, when he talked about 9mm weapons, he said the cheapest 9mm weapons are in the 200s. He said that the gun that she chose is a small gun. The gun that she chose is a light gun. And when she went to that store on April the 4th, she checked out at approximately 4:47 after going through the background check and clearing it. And if you look, that gun cost $229. She bought the cheapest gun they had and just whatever ammunition they told her to get, because this was going to be the gun to take her life. So why spend a lot of money on it? After she left the gun store, she went back to her house. She did not want to stay there long because she was afraid her adult son would come home. Poured the bullets out on the bed, grabbed a handful, shoved them in her pocket, shoved the gun in her pocket, and left after leaving him as much money as she could leave him. I think it was $500. She got in her car and she started to drive. She was not driving to Memphis, Tennessee. She was driving to Jacksonville, Arkansas, to Johnson Park. This was a place that had particular significance to her because of various names associated with it. Brodes Perry was from Jacksonville, Florida. Her ex-husband's last name was Johnson, and her dad's name was Ray. All of those were men that had hurt her in her life, but that she had also loved immensely. She did not want to commit suicide at home. She did not want her adult son to find her, to have to go through that. She knew that her suicide would be hard on him, but she didn't want that weight on him. At that point in time, she believed her son would be better off without him. As she's on the way to Jacksonville, Arkansas, she looks up and sees a sign. And that sign said, "This way to Memphis." And Latoshia thought to herself, if I can just see him one more time, I can find out why he is doing this, why he wants this to be over. Maybe I can change his mind. Maybe he will see that he still loves me. Maybe he will tell me that I am still worth loving. Maybe he will give me that reason to live. And she drove to Memphis. I want to ask, how many times have you been in your car running through thoughts in your brain as they race, and you analyze, and you're thinking, and all of a sudden you look up and you were like, how did I get here? I was on autopilot. This was not a cool, calm, do-do-do-do-do kind of drive. This woman was planning to commit suicide. This was not a drive to hurt anyone. She wanted to talk to him, not to hurt him. And she did talk to him. She went to the Pocket, which is a cigar lounge in downtown. She knew that he goes there on Thursdays. His wife knew the same thing. It was a frequent place that he went, not just on Thursdays. And Latoshia saw him and did as she was supposed to, walked past him until he acknowledged her. When he acknowledged her, they were allowed to engage, and she talked. They said that they sat there and talked for a long time, so long that the valet pulled the car away. And finally, by the end of the conversation, Brodes had said, "Look, we can be together if you're going to be okay with the ethical non-monogamy." And Latoshia said, "Then I want us to tell Tabatha." And Brodes said, "Okay, we'll go tell Tabatha. You go to the apartment, talk to her about tennis, talk to her about, whatever. Tell her you're in town for a conference. We'll tell her together." And so Latoshia goes to their apartment. It's unclear exactly what time she arrived at the apartment. It was somewhere between 9 and 10 o'clock, but either way, for the purposes of the timeline, we have that span that we don't have an exact time for. Some things we can get exact times for based on evidence, like that receipt, or if there's a phone call or something like that we can tie exact times to. We can't with this. Somewhere between 9 and 10 o'clock, Latoshia indicated that she remembered the news came on. So fair assumption there, 9 or 10. And this was in Collierville. Tabitha answered the door, and Latasha came inside. They sat on that couch and talked for 10 to 20 minutes. At no point did Latasha ever raise a gun to Tabatha. At no point did Latasha ever threaten Tabatha. At no point did any indication that she was anything other than happy to be there happen. And then Brodes got home. And when Brodes got home, Tabatha described him as being very agitated when he saw Latasha. Did he think he called her bluff? That she wouldn't really go? He knew that she was having second thoughts. Did he really think that she was going to go into the apartment and tell Tabatha after 2 years? And she was there. And he was facing down the possibility of having to confess to his wife. And instead of doing that, he offered her bourbon. He talked to her about why she was in this why she was here for a conference. And Latasha, when he walks in, becomes confused and off balance because she thinks this big conversation is about to happen and he's just making small talk. Even going so far as to say, well, if you're drinking, we probably need to clear those clothes off the guest bedroom. Latasha had never been there. And when she was there, Tabatha testified, and Latasha testified, that she didn't go into any of the bedrooms. She stayed in the main living area. That's a picture of the guest room. How would Latasha have known that there were clothes all over it? Unless Brodes said we would have to take all those clothes off the bed. She and Tabatha and Brodes sat in that living room for 10 to 20 minutes, talking, with Latasha just waiting and waiting and waiting, thinking, well, he's talking about a bed. Maybe we're going to segue there. And he wasn't even making eye contact with her. And at a certain point, he stopped even truly acknowledging her and just started talking to Tabatha. And Latasha realized he's not going to do it. He's not going to tell her. This doesn't mean enough to him. I don't mean enough to him. So I'm just going to go. I'm not going to bother y'all anymore. She does want to know why. Just as a practical matter, does it make any sense that she was sitting inside of an apartment with a closed door where no one could see in for about 20 to 40 minutes? If she was intending on killing them, why would she not have done it when they were sitting in there in private? Instead of after Tabatha walks out the door into opening it up into the outside. She is outside. Latasha's standing in the doorway. If this was a cool, calm, reflective judgment, why would she wait until that point in time? If this was the plan, why would she have not done it inside the apartment? Does that make sense? But instead of harming anyone inside of that apartment, Latasha got up to leave. And when she got up to leave, Tabatha went first and came out the door. And then Latasha was standing in the doorway, and Brodes was slightly behind her. Tabatha made it all the way down to the stairwell before she realized that Latasha and Brodes were not behind her. When she turned around, she saw Latoshia pull out a gun and shoot Brodes. That happened. What she didn't see and what she didn't hear was the conversation that Latoshia and Brodes were having at that door, where she said, "Walk me to my car. Be a gentleman. It's nighttime. Just walk me to my car." And Brodes just said, "Tabatha will do it." That emotional whiplash of being on the verge of killing herself to finding this hope that she can have the life that she has been trying to have with this man, to the disappointment of being dismissed by him, to this moment of just indifference, shattered her. Absolutely shattered her. And when she reached into her pocket to find her keys, she found her gun. And when she pulled her gun, that was not a calm and cool and reflected action. That was a heat of passion. She was so emotional in those moments. She did that act, but that was not a cool and calm act. That was a result of passion. As she's firing shots, she's yelling, "He broke my heart. He broke my heart." And when Tabatha starts trying to get close, Latoshia tells her to stay back. And Tabatha, who is very confused in this situation at this point, dives in front of her husband and tries to shield his body with her body. And during that process, had a bullet hit her in the shoulder. When she said, "Latoshia, you shot me," Latoshia said, "I didn't mean to shoot you." And Tabatha even told the police that she believed that Latoshia was not trying to shoot her. Tabatha felt like all of this emotion was directed at Brodes, because it was. But it was a lot of emotion. Officers arrive on the scene at 22:36, military time, 10:36, non-military time. When the police arrive, Latoshia still has the gun in her hand. Tabatha had told her, "Go, just go. They're coming. I can hear the sirens. Just go." And Latoshia couldn't move. She couldn't move. And when the police were yelling at her, telling her to put down the gun, what they saw and what they described was her staring blankly and talking softly to herself and repeatedly putting the gun up to her head or up to her mouth or up to her chest and eventually crouching down on the ground. And Officer Dunlap testified that he would have noticed if that slide was back and that chamber was empty. He didn't see that. The circumstances when the police got there, they're trained to assess. And they have this thing called the use of force continuum that officers kind of make a judgment on. Do I need to put my hands on this person? Soft hands? Or do I need to pull my sidearm and kill this person? And there are things in between. Do you believe that if the police thought that she was about to shoot the officers or Tabatha or Brodes in that moment, do you have any doubt that they would have shot the guns that they had trained on her? They opted for a non-lethal force because at that point in time, they deemed her a danger to herself. There is no part of what those officers saw that was cool and calm and reflective in Latoshia Daniels. They saw a woman in an emotional crisis. While the police were there, after Latoshia was taken into custody, they called the EMTs who came and rendered aid to both Tabatha and Brodes. They were then taken to the hospital where they both underwent surgery. Tabatha, thankfully, was okay. Brodes was not. He did die as a result of these gunshot wounds. That has never been in dispute. There are several things that are not in dispute. It's just a difference of whether you look at it from far away or come in close to actually analyze it, to see the details that make it up. Tabatha came in to testify, and she talked to you about what she saw on April the 4th and what she experienced. And she was utterly confused by all of this because she had no idea what was going on. She had no idea why Latoshia would be there because Brodes hadn't told her that he saw her earlier in the night. She had no idea that Brodes and Latoshia had had a 2-year-long relationship. That this woman was desperately in love with her husband. She had no idea. And that wasn't fair to her. That absolutely was not fair to her. But even Tabatha came forward to say that she didn't think that Latoshia meant to shoot her. She also told y'all that she watched the clips that we watched before. She never said any of those things. She never had those conversations. She never had those conversations with Latoshia. She didn't alley-oop him any woman. The hard nose for her was anyone. But he lied to his wife about that. And he lied to Latoshia about that. He lied to Chriselle and Danielle about that. The police department then start their investigation. They took Tabatha's statement. Chriselle actually reached out to the police department to provide them these videos because she believed that Tabatha knew all of this. That this would be so helpful to them because obviously Tabatha knew everything and he was being so honest and transparent that they needed to have this information. Instead, they handed over evidence that showed that Brodes was manipulating all of these women. They collected the receipt. They collected the video surveillance from the gun store. They did faraway view of what this was. And they looked at it and said, well, she bought a gun, she drove to Memphis, she went to Collierville, and she shot them. None of those facts are in dispute. Not a single one of them. But there's a lot more to it. There's a lot more to it. When she made that drive, she didn't go straight to Collierville. When she made that drive, she went downtown. Dr. Erica Curry came in and testified, talked about the gunshot wounds, trajectories, things like that. The fact that Brodes was shot multiple times is not in dispute. The fact that Latoshia is the one who shot him is not in dispute. She is not coming here to tell you, I didn't do this. She's coming here to tell you that when I did this, I was so overcome by my emotions that I behaved in a way that I would not normally behave. I would note, with the autopsy, it does show no stippling, no muzzle imprint. What that means is that the barrel of the gun was 3 feet or more away. When Latoshia was describing where everyone was sitting, and I believe Tabatha did too, Brodes was sitting directly next to Latoshia. He was in the blue chair. She was on the end of the couch. She was within arm's reach of him. And nothing happened. The other doctor that testified was Dr. Bidding. She is both a clinical and a forensic psychologist. The difference in those two things are one can kind of look at your whole picture and gather information for a legal process, and the other one can gather your whole picture and look at it for a diagnosis process. She does both of those things. And she has a very impressive CV to go along with it. And when she met with Latoshia, she did find a significant trauma history. She did not find malingering, which means no evidence of no evidence that Latoshia was not being honest in her answers on these psychological tests. She actually found that she tended to underreport her symptoms, which was consistent with her history of always having to put on a good face. Dr. Bidding does not just blindly rely on what someone tells her. She listens to what someone tells her and then compares it to outside sources, especially for that legal process. And she did that here. And she found evidence to corroborate what Latoshia was telling her. She read the police reports, including narratives about Latoshia's appearance on the scene. She read Tabatha Perry's statement describing what had happened. She watched the video of Brodes Perry talking to Chriselle and Danielle about seeing Latoshia at the cigar bar that night before going home to Carterville. He read Latoshia's journals. She read Latoshia's journals. And all of those corroborated what Latoshia was telling her. She had a history of depression, and she would not, the state was right, she would not offer an opinion on her state of mind at the moment of the offense. And that's what matters legally, is at the moment. However, she did have a position about her mental state around the time of the offense. The reason that she could not speak to at the moment of the offense was because Latoshia has trouble remembering those moments, just like Tabatha did, because trauma can do that to your memory. Around the time of the offense, again, corroborating by all of those items of information, she believed that Latoshia was exhibiting depressive symptoms and emotional dysregulation. she was in turmoil. She told you sometimes people who truly want to die are hoping that someone will give them a reason to live. And that's what Latoshia was doing here. When she parked her car in downtown Memphis, she truly wanted to die. But she was hoping with every part of herself that Brodes would give her a reason to live. Latoshia talked to you, and she told you her story. From a young age, all the way up to reaching out to Brodes for counseling, through their relationship, about his rules, about her love, about the fact that he had told her that Tabatha was on board with this. He just hadn't told her yet about Latoshia. She told you about that emotional whiplash that she suffered for that last month leading up to April the 4th. She was getting pulled by her heart in so many different directions. And she talked to you about the fact that the moment that her hand went into her pocket was a moment when she was shattering. That was the word that she used. In that moment, she shattered. The timeline in the case supports what Latoshia told you happened. At 3:14, we have a suicide note written, which is before going to buy a gun. She then takes a quick trip home and then leaves for the park. Driving down 440, where there's a split for Memphis. She proceeds towards Memphis and arrives downtown, speaks with Brodes for a long time. Latoshia then drives to Collierville, sits in the parking lot, calls Brodes, starts to have some second thoughts, and Brodes says, "No, go on in. Go on in." Latoshia goes to the apartment. Tabatha lets her in. They talk for 10 to 20 minutes. Brodes arrives back home. They talk for 10 to 20 minutes, and then Latoshia says, "I'm going to leave now." Police respond at 22:36, again, 10:36 Central Time. And by 10:36, Latoshia is still standing there with the weapon in her hand. If she left Arkansas at 5 o'clock, and it only takes 3 hours to get to Collierville, why was it 10:36 when police arrived? Unless there was something that happened in between. And we know that there was something that happened in between because Brodes made a video saying, "Guess who I just saw as I'm walking out of the cigar lounge?" All of that corroborates what Ms. Daniels came here to tell you. And I can tell you, sitting on that stand is not easy, especially talking about the things that she had to sit up there and talk about. She's not proud of what she did. She is extremely remorseful for what happened that day. When the prosecutor during cross-examination said, "You went there to shoot him, didn't you?" She said, "No, No, ma'am, I loved him. I would never hurt him. No, that was not my intention. Because she didn't come to Memphis to hurt him. She was planning on hurting herself. And she walked into that apartment happy to be there in the hopes that she would get some semblance of that love back. Very briefly, I'm going to talk to you all about the law. You have your jury instructions, and there are some that I would like for you to cue in on because they're very important. If you remember during jury selection, voir dire, we talked about criminal offenses and what's required. And what's required is an act and an intent. You have to have both. When you look at what are called lesser included offenses, the act never changes. The intent is what changes. On count 1, the lesser included offenses are all of the offenses: first degree murder, second degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. As I told you, Latoshia Daniels pleads not guilty to first degree murder. I submit that the appropriate charge in this case, as it pertains to Brodes Perry, is voluntary manslaughter. Voluntary manslaughter is an intentional and knowing killing that occurs during a heat of passion. That is exactly what the facts before us in this trial have laid out. Premeditation requires the exercise of reflection and judgment, careful consideration, sufficient freedom from excitement and passion so as to be capable of premeditation. When you are in that emotional state of passion, you can't reason properly. That's why premeditation requires the absence of all of those emotions to truly and thoughtfully judge and reflect on your actions before you take them. The emotions cloud that ability and impair that ability. A heat of passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which render the mind incapable of cold reflection. I submit to you, ladies and gentlemen, that that is exactly what we have here. This was a voluntary manslaughter. This was not a first-degree murder. And I told you from day one that Ms. Daniels was not coming here to tell you I didn't do anything wrong. She knows what she did was wrong. She feels that every day. But that doesn't mean that that was a cool, premeditated act. Count 2, the account pertaining to Tabatha Perry, Archie. Criminal attempt first degree, criminal attempt second degree, criminal attempt voluntary manslaughter, and reckless endangerment. Those are the lesser included offenses as they pertain to her. I submit to you that the actions that led to Miss Perry's injury was reckless endangerment. The process that involved Miss Perry getting shot, she actually put herself into that line of fire, and Miss Daniels did not even mean to shoot her. Miss Perry even believes that Latoshia was not trying to shoot her. Tabatha told the police that. Tabatha told y'all that. The police told you that. She tried to shield Brodes, and in the process she got hurt. And that was an unacceptable risk that Latoshia took when she fired those shots. And she should have known that firing those shots in that apartment could have ended up hurting Tabatha. And that's exactly what happened. The definition of recklessly in your jury instructions is found on page 9. That is where, when you look at reckless endangerment, it will refer you back to the other definitions. That's where you find recklessly. A person acts recklessly when they are aware of but consciously disregard a risk that is substantial and unjustifiable that the alleged victim will be killed. Because it's under the reckless homicide, they refer to actual killing. It's applicable also to the reckless endangerment without a killing. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under the circumstances as viewed from an accused person's standpoint. She had absolutely no intention to hurt Tabatha, but firing those shots was a risk that she would. And she did hurt Tabatha. I submit to you that the appropriate charge on count 2 is reckless endangerment. All of these must be proven by the state beyond a reasonable doubt. And we talked for a long time in voir dire about beyond a reasonable doubt. The prosecution must present evidence that is so convincing that it leaves no other logical explanation for the facts except that the accused is guilty of the charged offense to a moral certainty. One of the elements that must be proven is the intent, is Latoshia Daniels' intent. So if you come down and you have one version of this event where this is a cool, calm, premeditated murder, and you have another version of events where this is a woman who was in an emotional distress, and both of those are reasonable based on the evidence, then the state has not carried their burden as to first-degree murder. The appropriate charge would be voluntary manslaughter. And that burden is very, very high. You can see both of those things if you step back and look at it and understand that while you may see two faces, you may see an apple core. And it's reasonable to see both of those things. No matter which one you looked up and immediately saw, or which one you prefer, both are reasonable as an explanation of what you see in that picture. This is the state's case from far, far away, looking at these facts. Facts that are not in dispute, but they are missing the actual picture and showing you something that isn't really what this was. I'm asking you to look at all of the evidence that has been presented to you over the course of this week and to see the details of what that picture actually is. Thank you.
Any jurors on the board? State, go.
You've heard all the evidence and most of the arguments. And the assumption at this point, based on our history, is I'm not going to be up here for an hour and a half, right? And I thought about that yesterday and more today, and I hope you appreciate that. But I don't want you to take that to mean that I don't have anything to say about this case, or that I don't want you to understand how significant that the proof is in this case, because it's significant. And it's almost so clear that it just doesn't take a whole lot of time to explain it to you. or to prove it to you. So if I can just take a few minutes to go back through there just to remind you of what we're looking at. The proof is clear even by her admission that she got a text that morning that said this relationship is over. I don't want to be in it anymore. And that shouldn't have been, and probably wasn't, a huge surprise to her. Because for the past months, weeks, she was even going to break up with him at one point. You know, really since he had moved from Little Rock, the relationship hadn't been the same. So what did she do in response to that? And she can tell you, this is what I plan to do. But the proof is she immediately went to buy a gun and immediately drove to Memphis to find him. 3 hours. And that's not disputed. She says, I was going to kill myself. But she wound up in Memphis with him. And she wound up at his house. She was still there when the police arrived. She shot him multiple times and shot Tabatha Perry Archie in the process. I mean, that's overwhelming proof of intentional premeditated murder, and she agrees all that happened. Do you remember there was a discussion, I believe it was in jury selection, about we do things different here than we do in the real world? I mean, I don't really know what that means. Because what we know is that in the real world, Brodes Perry is not here to tell this story. That he was shot and killed in his own home in front of his wife. And we know that Tabatha was shot while kneeling next to her husband, trying to protect him and help him and begging her to stop. You know, there's a lot of talk about reflection and judgment, cool, calm, and collected. Well, she was cool, calm, and collected enough to say, according to her, Tabatha, get out of the way. She doesn't remember anything, but she knows she didn't mean to shoot Tabatha. I mean, that's in the real world. And this is hard, I know. Talking about Tabatha, it's a good time just to point out, I mean, there is transferred intent. And so we don't have to prove she was trying to kill Tabatha. Just that she was trying to kill somebody, and she was trying to kill somebody. She did kill somebody. And in that process, she shot and caused serious bodily injury to Miss Archie. So when you have a case like that, with those facts that line up perfect, I get the text, I go buy the gun, I drive to Memphis, I show up at his house and I shoot and kill him. You got to come up with something as a defense, right? So the defense is, I'm the victim. And I'm going to talk about that a little bit in a minute, but I want to talk to y'all a little bit about who she is, who is claiming that she's the victim in this case. It's an almost 40-year-old grown woman who has a doctorate degree, who has been twice married and twice divorced, who runs her own business, and who voluntarily entered into and started this affair with Brodes Perry. She admitted that. I liked the way he made me feel. I was wanting that kind of relationship at that time. She knew he was married. She had dinner with, she played tennis with his wife. She knew that Tabatha wasn't aware of this affair. you know, that there's rules. Brodes had rules. Well, I mean, one of the rules was we've got to talk to each other on this app that's not easily traceable. Is that a rule? Or is that what you would expect? Two people who were married because they were both married when it started, that they might come together and say, you know, we probably don't need to text each other and email each other on our phones and on our computers. Because we got to hide this. Is that a rule? Is that manipulative? Can't go out in public with just the two of us because we don't want to be seen as a couple. Is that a rule? Or is that what you expect? When two people who are married decide they're going to have a sexual relationship and hide it from their spouse. Is that manipulative? Did she ever say anything about he forced me to be in this relationship? Did I miss something with that? Or did she say she liked it? She wanted to be in that relationship. I can't put your plane tickets on my card. Is that a rule? Is that what you call that? You know, she couldn't make one trip, so she said, so I decided to go on the Jerusalem trip because I couldn't make it on the wherever the other trip was, Cuba or something. So hey, I want to go on this other one because I didn't get to make that one. Is that you're expected to go? Or you want to go hang out with the married guy of my friend at a hotel room in Israel? Which is it? I don't want you to call 911 if there's like some kind of medical emergency. If you were staying in a hotel room with the person you're having an affair with, do you want her calling 911? How does that make Brodes Perry manipulative? She drank bourbon with him. She smoked cigars with him. She knew about his interest in this book. She read the book. She understood that he was interested in this non-monogamy lifestyle. She even tried to recruit one of her friends to help him out with that. A 38-year-old grown woman with a doctorate degree who run a business and has been twice married and twice divorced. You know, one of the things that happens when you kill somebody is there's only one side of the story that gets to be told because there's only one person that's left alive. And so we spent a lot of time talking about how bad Brodes Perry was. We played videos for his widow and made her sit there and say, no, I didn't know that. He was lying to me. It seems illogical, but it's sometimes easier to feel sympathy toward the person who's still alive than it is the person who died. Because that's the only story you get. And she made terrible decisions. And you feel bad for her because she made those decisions. But they were her decisions. If Brodes was here, would he say, I'm sorry, I wish I hadn't done that way? We'll never know, will we? Did he make mistakes? You know, I want to quote to you from the jury instructions because I think it's important. Because you can't look at her and say, I feel sorry for her because she made that decision. This is a quote. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. So feel sympathy toward her, but don't let that affect your verdict. You'd be inhuman not to feel sympathy toward her. But we talked about earlier during jury selection how sympathy and prejudice are not appropriate, and how you look at the facts, and if you determine that she intentionally, unlawfully, and premeditatedly killed him, it doesn't matter how sorry you feel for her. Because you're not supposed to use sympathy. Was Brodes honest? He lied to his wife. He lied to his church. He lied to two people in a book club on an app where they sent videos back and forth to each other who he had never met. You want to be married to Brodes? Maybe not. Did he lie to the defendant? I don't know if we know that. I mean, she knew he was married. She knew they were hiding the affair. She knew Tabatha didn't know. She knew about the book. She knew he wanted the non-monogamous lifestyle. She knew that early in the relationship. She read the book. What do you lie to her about? Probably more honest with her than he was anybody else. He may have lied to her. Lying and being immoral is not a capital offense. Latoshia Daniels also made a lot of choices. She got to tell you she's not proud of them. Brodes didn't. She made a choice to start the affair. She made a choice to continue the affair. She even made that choice after she claims that he made her feel bad in the hotel room to continue that affair. She made the choice to hide the affair. She chose to go purchase a gun after she got that text. She chose to drive from Little Rock to Memphis. She chose to go to the Perry's house. She chose to take her gun into their home. And you'll note that premeditation, if done prior to the act, like, so you can premeditate a murder, and then you can go to do that murder, and you can be overcome by adrenaline, excitement, any other emotion you can think of. But if you premeditated it before you do that, and then you follow through with the murder, that don't negate the planning that you did beforehand. Why didn't she shoot him when the door was closed? Think about it all you want to. It's probably hard to pull out a gun and shoot somebody, even if you plan to. You can plan that all the way from Little Rock to Memphis, and it still may be hard to pull the trigger. She made a decision to shoot and kill Brodes Perry, and she made a decision to shoot Tabatha. One of the defense witnesses was Dr. Bidding. What do we glean from her? That's helpful. Because I don't doubt she was depressed, and that's what Dr. Bidding said, she was depressed. And I'm not taking that lightly. Depression is an awful disease that affects millions of people. But Dr. Bidding said it doesn't mean that you can't. Sorry. Dr. Bidding said it doesn't mean that they commit violent acts because they're suffering from depression. Depression doesn't cause that, and depression doesn't cause you to lose your ability to plan, use judgment. And she specifically said that depression is not a cause of impulsivity. So if depression doesn't negate intent and premeditation, it doesn't keep her from being cool, calm, collective, it doesn't keep her from using reflection and judgment, is that helpful to us? You also heard from Dr. Bidding about this defense under Tennessee law called insanity. And what she said was, there's a defense in Tennessee. And if a person is of this mental state where you can't appreciate the wrongfulness of your actions, then they can be found not guilty of the crime, because there are two things, the act and the intent. And she said, this insanity applies when someone is not able to appreciate the wrongfulness of their actions because of their mental state. And I said, well, did you evaluate the defendant for the criteria for insanity? Yes, it was not there. Insanity would not, the criteria were not met when I evaluated the defendant for that. You also heard Dr. Bidding talk about what she called diminished capacity, which in Tennessee is this, you might still be guilty of something, but you're not guilty of the more serious offense because your capacity is diminished because of your mental state. And again, I asked Dr. Bidding, a defense expert, a witness called by the defense. What about when you evaluated Latoshia Daniels for this diminished capacity? Didn't meet the criteria for that. Well, Dr. Bidding, the defense expert, what about post-traumatic stress disorder? Did she meet the criteria for that? No. No, she didn't meet the criteria for post-traumatic stress disorder. Dr. Bidding, the defense expert, does potentially wanting to harm herself, does that negate intention and premeditation? Can't say that it does negate intention and premeditation. Well, tell us, Dr. Bidding, about her mental state at the time she committed this offense. I'm unable to provide an opinion about her mental state at the time she committed this offense. What about Dr. Bidding's testimony did you find helpful? I found helpful the fact that she said she did appear to exercise judgment just prior to this homicide. And she did appear to engage in planning in the moments leading up to this homicide. So we've talked about she used judgment, had a cool, calm, and collected thought when she told Tabatha to get out of the way. I don't want to shoot. Dr. Bidding says she has cool, calm, and collected thoughts all day, up to the moments before the homicide. Then we heard from Officer Duncan, who said he pointed, I saw her point the gun at herself. She was holding the gun. When I got to the door, I said, drop it. She pointed the gun at herself. At some point during that day, did she intend to harm herself? I don't doubt that. But I can tell you what she had at that moment. She had the judgment and reflection not to harm herself. She had the judgment and reflection not to point that weapon at the Carterville Police Department because they had a gun pointed at her. Where's the lack of judgment and reflection? Was she devastated? Was she in love? Were her feelings hurt? Had she spent 2 years in a relationship with a married man and she realized he wasn't going to leave his wife? I don't doubt that. Did she know what she was doing? Yes. And it's unfortunate. It's unfortunate for her. It's unfortunate for Brodes Perry's family. Unfortunate for the widow of Brodes Perry. That doesn't change what happened. Did she plan this all the way from Little Rock? And I'm going to change a little bit and talk about something different here, and I want to be very clear about what I mean when I'm doing this. I submit the proof shows that she did plan this from the time she got the text. But I want to talk about why I think that's not required. It's impossible to know what she was thinking because we can't read her mind. Was she planning to kill Brodes and herself? Maybe. That doesn't negate the fact that she killed Brodes and that she did it on purpose, intentionally, with premeditation. Did Brodes ask her to go to his house? I mean, his reaction says no. The history between the two of them says no. A hidden app. Got to have somebody with us. We went 2 years, we hadn't told her. He didn't want Tabatha to know. So the history between them indicates no. So the evidence is contrary to her description of what happened. And again, I'm going to emphasize that because I'm going to make another argument. But I want to read. The evidence is contrary to what she describes as happening. But it really doesn't matter. She's asking you to consider voluntary manslaughter. And kind of the difference is the killing resulted from a state of passion produced by adequate provocation from the alleged victim. Sufficient to lead a reasonable person to act in an irrational manner. Well, there's no question she acted in an irrational manner, because it's hardly ever rational to point a gun and shoot a guy 7 times who's not threatening you, doesn't have a weapon, and is not even, there's not even a chance he's harming you physically. No even history of him harming you physically. So that's never a rational act. So the second part of that is very important, because it can't be adequate provocation that makes Latoshia Daniels act in an irrational manner, because she did. And all you would have to say is, yep, there was some provocation that made me act irrationally, so I'm not guilty of homicide. I'm not guilty of murder 1. It says sufficient to lead a reasonable person to act in an irrational manner. Did what happened to her, is that enough to make a reasonable person act that way? To point a loaded gun at an individual who's unarmed and not threatening you and pull the trigger not once, not twice, not 3 times, not 4 times, not 5 times, not 6 times, but 7 times. Somebody talked to you about the classic law school example of voluntary manslaughter, where someone comes home and they find their spouse in bed with somebody else having an affair. And before they have time to reflect on that or cool down, they kill either their spouse or the person they're having the affair with. And that is the classic law school example. Latoshia Daniels doesn't fit the classic law school example. Her spouse was not having an affair. She didn't react immediately to some huge thing like that. Somebody hit my child or whatever. She knew this relationship was coming to an end. And she knew about this affair for 2 years. And she knew Tabatha didn't know about it. So again, it's not voluntary manslaughter. So I want to look at her story and set aside all the other evidence for just a moment. Not conceding there's not all the other evidence, but I want to just set it aside for a minute. What was the adequate provocation? He wouldn't walk me to the door? To my car? It's the only provocation I heard. Because right before that, she was talking, and she even made a decision. I feel like I'm being played, was what her testimony was. I'm embarrassed. I want to leave. Is that a person overcome but doesn't know what they're doing? And she had known since that morning he was ready for this relationship to end. And she had known for months that the relationship was not what it had been. That's not provocation that would lead a reasonable person to act in an irrational manner. It may be provocation that would break your heart, that would hurt your feelings, that would cause you to be really upset and really mad and really regretful, maybe ashamed, maybe embarrassed. She told you why she did this. And to convict, all you got to do is listen to her. She told Brodes. I don't know if he heard her because he had a bullet in his head. You broke my heart. That's why she did it. The evidence suggests that she made the decision to kill him. Maybe herself that morning. But even if she made it when he declined to walk her to the car, it's first-degree murder. There's no time period required for premeditation. Some of the things you can look at, she shot an unarmed, unthreatening person. She was making decisions that she felt like she was being played. She was embarrassed. She was walking to the door. She reached in her pocket and pulled out the gun that she had brought into their home. She didn't go back out to her car to get the gun. Was it for protection from her car to the door, or did she forget it was there? We heard both sides of that story. And she shot him 7 times. And killed him. How can that not be intentional and premeditated? Even disregarding all the evidence except what she tells you. How can that not be intentional and premeditated? Especially considering Dr. Biding's testimony. And all the things she did. Tabatha, get out of the way. Not pointing the gun at the police. Not harming herself. Where was this total loss of judgment? She was hurt. She was mad. She was embarrassed. She didn't like what Brodes had done to her. What Brodes had done to her. I ask you to follow the law. Apply the evidence to it. And if you do that, I submit you'll find that she's guilty as charged on all 3 counts of the indictment. Thank you.
All right, now it's time to select our alternates. All right, Mr. Lord and people will be our jury. I'm going to send you back with the instructions, the indictment, and the exhibits. I think except the firearm. The first thing you will need to do is select a 4-person. And when you have a verdict, you will write your verdict on the verdict form. I will review the form to make sure that it's in proper form, and then I will have the jury foreman read the verdict. So I'm going to show the people who are on the jury, excuse the alternates. If you could remain, you can finally discuss the case. So I'm going to show you excuse at this time.
Folks at the table, if you bring your paperwork with you.
All right, Mr. Lord. All right, Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And Mr. Lord, you will be our jury. And Mr. Lord, you will be our alternates. And
You may be seated. I understand the jury has reached a verdict.
Yes,
Ms. Harvey, you will be, you can stand and read the verdict. Each of the verdict forms.
Do I need to start from State of Tennessee versus? State of Tennessee versus Latosha Daniels, indictment number 25-01253. Verdict form count 1. We, the jury, find the defendant guilty of second-degree murder as included in count 1 of indictment number 25-01253. State of Tennessee versus Latosha Daniels, indictment number 25-01253, verdict form count 2. We, the jury, find the defendant guilty of reckless endangerment as included in count 2 of indictment number 25-01253. State of Tennessee versus Latosha Daniels, indictment number 25-01253, verdict form count 3. We, the jury, find the defendant not guilty in count 3 of indictment number 25-01253.
Would you like the jury poll?
Yes, please.
Okay. I'll start on this end. Is that your verdict?
Yes.
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 Is that your verdict? Is that your verdict?
Yes.
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 Now that you have concluded your service on this case, I thank you for your patience and conscientious attention to your duty as jurors. You have not only fulfilled your civic duty, but you have also made a personal contribution to the ideal of equal justice for all people. You may have questions about the confidentiality of the proceedings. Because the case is over, you are free to discuss the case with any person you choose. However, you do not have to talk to anyone about the case if you do not want to. If you tell someone you do not wish to talk about it and they continue to bother you, let the court know, for we can protect your privacy. If you do decide to discuss the case with anyone, I would suggest you treat it with a degree of solemnity, so that whatever you say, you will be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of all the parties. Also, if you do decide to discuss the case, please respect the privacy of the views of your fellow jurors. Your fellow jurors fully and freely stated their opinions and deliberations with the understanding they were being expressed in confidence. Again, I thank you for your willingness to give of your time away from your accustomed pursuits and faithfully discharge your duties as jurors. You are now excused. I will be back to speak with you shortly, so I'll show you excused to the jury room. Ms. Daniels, if you would please stand. A jury of your peers has found you guilty of second-degree murder in count 1. The jury has found you guilty in count 2 of reckless endangerment, and the jury has found you not guilty in count 3. As a 13th juror, I approve that verdict. We'll show your bond revoked, and we'll show this matter set for sentencing. January the 12th. Is that the good one?
We'll need to do a pre-sentence report. If we could get a shorter date to get the pre-sentence report back,
Okay.
that way we don't have to reset it once we get it.
Okay.
We can reserve January the 12th
Or
and
just
then get a sooner date for the report.
Actually hoping to be in Cabo that week.
On January 12th?
I'm hoping.
Okay. We'll get it.
December or?
We can get a December date and then pick a date that's fine. It's just to get the report.
December 17th.
December the 17th, a good day. All
Yes, Your
right.
Honor.
Yes.
All right, we'll show this matter set for sentencing on December the 17th. All right, we can show court adjourned.
All rise. This all the court stands adjourned till Monday morning, 9 a.m.